Jim Hibner, our appellate court clerk, will now call our first case.
Teresa Thompson Locke et al. Versus Jason D. Aston MD et al.
Good morning.
Good morning, counsel.
May it please the court, Jeffrey Zager, along with Olivia Arbonneau on behalf of the appellants, Teresa and Randy Locke. I'd like to reserve 5 minutes of time for rebuttal and commandeer that space, if I may. This interlocutory appeal centers on the discoverability of surveillance videos. Specifically, what happens when one party obtains surveillance videos of another, but declares that it only intends to use some rather than all of the surveillance videos it has obtained. The trial court below, relying on a Michigan federal court trial court decision, limited discovery to only those videos that the defendants intend to use at trial, concluding that the plaintiffs do not have a substantial need for videos that will not be played at trial. That conclusion finds no support in Tennessee case law, and it runs counter to the basic notions of fairness and transparency that are embodied within our rules of civil procedure. More problematically, it has the practical effect of allowing a party to unilaterally render surveillance videos immune from discovery simply by declaring that it has no intent to use those videos at trial. I think the facts and the procedural history of this case are fairly undisputed, and so unless the court has specific questions about those, I'd like to dive into the issues at hand. And
Mr. Zager, let me ask you, does the substantial need test, according to your position in this case, should we retain the substantial need test, or is that, did you answer? I'm sorry.
I see no reason to disagree as to the legal framework, which includes the substantial need test. So our position is not that substantial need should be read out of Rule 26 or out of the analytic framework for discoverability of work product or surveillance videos. The dispute here really centers on how do we go about that assessment of substantial need, specifically in the context where a party has obtained surveillance videos and expresses an intent to use some but not all.
Did you ask for an in-camera inspection in this case?
We raised the issue of, and I guess it is somewhat important here to retrace the procedural history. The original discovery request sought surveillance videos. An objection was made, work product was raised as the basis for not producing those. In the original motion to compel, which was filed, we pointed out that there had been no privilege log provided. In connection with the response to the motion to compel, a privilege log was provided. I think it's Exhibit B to the defendant's response. That privilege log lists 6 videos, 6 entries, and an investigator's report. Through the initial motion to compel hearing and then the subsequent hearing on the motion to amend the trial court's ruling, it became evident that the 6 entries in the privilege log represent only the videos that the defendants intend to use, not the videos that are still being withheld under a claim of work product and that the defendants have offered they do not intend to use. Once that became clear, yes, we did raise at the trial court, this is in violation of Rule 26, there has been no identification of what is being withheld, and we can't even really fairly assess substantial need until we actually know what is being withheld. For whatever reason, that argument got very little traction at the trial court and was never really addressed. It's not addressed in any of the court's rulings or orders. So yes, we did raise the issue that we have not even been provided a privilege log that identifies what specifically is being withheld. The only information we know about what has been declared not discoverable is that it's not going to be used at trial. We don't know how many videos they are. We don't know what they show. There was certainly no assessment by the trial court of any actual information about the videos other than the fact that they will not be played at trial.
So were the 6 that they intend to use, were they produced?
They were produced after the trial court's ruling, I believe after the ruling on the motion to amend, at least after the original ruling on the motion to compel. Okay,
and then you asked for a privilege log for the other videos that weren't produced?
We asked for a privilege log from the outset, yes.
Okay.
But did they ever provide, so they have never provided a privilege log for the other videos in their possession that they do not intend to use at trial.
That's
Is that
correct.
How does that, if at all, affect who bears the burden of persuasion on these privilege issues? I mean, is it your argument that they haven't actually properly invoked the work products protection for those videos because they failed to list them on a privilege log?
I would certainly say that that's a fair argument to make. I think it also speaks to the fact that the trial court's ruling is a ruling of law, because as a practical effect, there was no ability for the trial court to actually assess these videos because the only information the trial court knew about the videos was the fact that they were not going to be played. So it's a bit of a misnomer to suggest that the trial court actually assessed substantial need. There was no in-camera review. The trial court knows nothing about the videos other than the fact that there is no intent to play them at trial. And I would say that, yes, that does, I think, fail to comply with Rule 26 in terms of raising work product. I think Rule 26 is pretty clear that if you're going to make a work product objection, you need to provide the other party and the court with some information to fairly assess the validity of that claimed privilege. Here, the only information that was provided to support that claim was, well, we don't intend to use them at trial.
Let me press a little more on the question that Justice Tarwater asked a moment ago about what the correct framework is here. So in response to that question, I believe you argued that you agree that the substantial need analysis is the right way to approach this. But it seems to me there are sort of two ways to look at the legal issue here. The first is, whether there was a sufficient showing of a substantial need for these materials kind of within the Rule 26 framework. But another way of looking at this is that the defendants, by intending to use certain of these videos at trial, have waived any applicable work product protection as to those videos. And then the question becomes, what is the scope of that waiver? As part of that waiver, are they also now required to disclose the other videos that are related to those, so that, under the rule of completeness or just principles of kind of equitable fairness, you have the full picture. I know you made an argument in, I think, your brief to that effect, that this is kind of about the rule of completeness or waiver. How does that fit into this? Did you make that argument below? What is the right frame? Because those are really two different ways of looking at it. I think if it's a waiver, if that's really the framework that we're within here, then whether you show that there's a substantial need for these materials is sort of irrelevant to that inquiry. So what is the right way for us to look at this?
I agree completely, and I think that Your Honor is correct that those are two equally valid ways of approaching this question. And we did talk about waiver in the context of sort of the sword and shield argument about when a party voluntarily elects to put forth some information that it was previously claiming a privilege to, it cannot then at the same time claim privilege for some other subset of the same information. I think this court has made that abundantly clear in the Boyd opinion, which I think the defendants place great emphasis on Boyd. Boyd is very clear that litigants may not use the work product doctrine offensively as a sword to make a point and then selectively disclose information that they wish to and relinquish that work product doctrine effect, while at the same time invoking the work product doctrine to prevent the other side from making a counterpoint. And so I do think that there is waiver in that context.
But did you raise that argument in the trial court?
Not initially, and in some respects that was a function of the procedural posture, because the original motion to compel was in the context of an objection to written discovery simply saying we're not producing any videos, they're all work product. It wasn't really until we got to the motion to alter or amend, after the trial court had already ruled on the motion to compel, that this new theory from the defendants emerged of, well, we should only have to produce some, not all.
So it wasn't until that motion to alter or amend that the defendants sort of indicated to the court that they did plan to use those videos at trial? Is that right? Is that the point in the proceedings at which it became evident that some of those videos would actually be played at trial?
I think that is correct, that it wasn't until the motion to alter or amend that it became clear that there were additional videos being withheld that the defendants did not intend. Now, if it may have come up in the hearing on the motion to compel initially. I can't recall, it's been several years. But certainly the motion to alter or amend was the first time that the defendants specifically asked the trial court to carve out an exception to say, well, we should only have to produce the videos we intend to use, which to me was their clearest statement that there are other videos being withheld that are not contained in this privilege
And
list.
at that point, did you raise an argument about, waiver of the work product protection or the rule of completeness or anything with any argument kind of within that framework?
I believe the argument that would be contained, which would have been in our response to that motion to alter or amend, did include the sort of sword and shield argument about it, particularly, it was probably framed in the context of substantial need, but to me, they overlap there in terms of the policy rationale that, when you are affirmatively seeking to use surveillance videos, there is, of course, a substantial need for all of them. And that goes hand in hand with the idea of you have voluntarily elected to waive the work product doctrine with respect to some subset in fairness, in full transparency, to provide context to the jury. They all ought to then be disclosed. So I think it goes hand in hand with the substantial need context. I can't tell the court specifically from my recollection whether we made a specific waiver argument, but to the best of my recollection, we did raise that sort of sword and shield type of argument at the trial court.
To follow up on Justice Campbell's question about the rule of completeness, why would an evidentiary rule, which is right there in Rule 106, apply to a discovery dispute?
It's not binding, but I think it's instructive in the policy rationale that it embodies, which is that in fairness, the full context of evidence ought to be provided to the jury, and that we don't let sort of hyper-technicality allow one party to display what is objectively going to be misleading information to the jury, when in fairness, the full context ought to be displayed.
Okay, let's follow up on that a bit, because I'm interested in your position on that. And let's move to the other side of the V, to a day in the life video. Is it your position then, so if you represent a plaintiff and you produce a day in the life video that may have hundreds of hours of footage, and you elect to play 15 or 20 minutes of that footage for the jury, that all of the remaining footage should be produced to the defendants?
I do. I think it's the same argument. I think a day in the life video is no different than surveillance video. It's just voluntary surveillance video. And I think if there's a substantial need for one, there is a substantial need for the other.
But the substantial need test applies, right?
I think that certainly is the test that every court that we've looked at in these cases is applying. I will note, I think it was an Illinois case that was, I think, cited by the Tennessee Defense Lawyers Association in its brief.
Helms, is that the case?
I think it started with a C, but one of the parties may have been Helms. And
well, C for you, H for me,
It's all relative. And in that case, the court, I think, held that it would reserve ruling in the context of a day in the life video. It would reserve ruling on the discoverability of the day in the life video, including the unused footage, until the plaintiff made an election of whether or not to actually use it at trial. And I think arguably you could make the same argument in the context of surveillance videos. That issue isn't really before the court, because here we already have an affirmative statement from the defendants that they intend to use surveillance videos at trial. But I think that would still be a fair carve out to raise that, it's a different question of what happens if a defendant says we have surveillance videos, but we don't intend to use any. Is there a threshold requirement of some intent to play some video to then trigger a substantial need to all videos? Either way, it's still the same analytical framework of substantial need.
So here in this case, what you're saying is if the defendant said, we've decided we're no longer going to use any of this video, then you would no longer have substantial need to see it.
I wouldn't feel so comfortable as to establish a bright line rule that if one party declares it has no intent to use the videos, there can never be substantial need. I think the framework would still be the plaintiff's burden to establish substantial need, and I would think it would be a more difficult task
But
in that
right
context.
right now, your need is really on a completeness level. We want to see if the video that they are seeking to use is somehow selectively edited, misleading, and so forth.
Correct.
So that argument just wouldn't hold anymore.
That's right. That's not to say that there might not be a different valid substantial need argument in the context of a
Right.
situation where no videos are going to be played, but I think it would certainly be a more difficult
But
road.
in this case, you would agree that if they were to say, we're no longer going to do that in this particular case, you in essence would not have a substantial need for those videos?
We certainly wouldn't have the same substantial need argument that we have, and I can't envision a different substantial need argument in the context of this case. You know, the examples I'm thinking of is perhaps if the plaintiff passes away, or if there's some really unique situation where this
Right.
video there is a substantial need for it. Those circumstances don't appear to present here.
Okay, thank you.
And so as I see it, there are, I think, three outcomes that this court, three paths that this court could take with this case, and any one of which would be certainly permissible. I'll offer them in my order of preference. The first would be that this court, our position would be, can and should establish a bright line rule that anytime a party announces an intent to use some but not all of the surveillance videos in its possession or custody or control, then there is, as a matter of law, a substantial need for discovery of all the videos. I think if the court is unwilling or uncomfortable with such a bright line rule, then it can, at least in the context of this case, of the facts that are in the record in this case, conclude that there is a substantial need for discovery of all of the surveillance videos based on what we know about this case.
And how do we do that? With no privilege log, with no in-camera inspection?
Because we do have a privilege log, and
Well,
and-
I know,
and-
but the videos on the privilege log are the ones they intend to use at trial.
correct.
Okay, so there's no listing of any video or any piece of evidence that they are claiming the work product doctrine for. So how are we then to determine substantial need?
Because in this context, the other piece of information that we do know from the investigator's report, which is also contained on the privilege log, is that all of the surveillance, the entire universe of surveillance, both what they intend to use and what they do not intend to use, was taken on the same day. And so that, to me, is sufficient to establish substantial need in terms of providing context for this particular universe of videos. I think it might be a different question if there was such a gap in the temporal space. That would perhaps be an argument that the defendants could say, well, you have a substantial need to see the context of this group of videos, but this one was years later. We're not going to play it. It has nothing to do with this subset. That's not this case. We know that all of the videos here were taken on the same day. And so I think
And that's supposed to establish substantial need because they were all taken on the same day?
I think so. In the context of this case, with Rule 26 as a backdrop, I think that is sufficient to establish substantial need.
But wouldn't it perhaps make more sense if we were to not want to adopt a bright line rule, as you've articulated as option number one, that we send the case back to the trial court with instructions to have the defendants produce a full privilege log, and then the trial court could do an in-camera review of those items?
Yes, and that is my option number three, which
Okay.
is that at minimum, this court should remand the case to the trial court for an in-camera review of the withheld videos with the instruction that the non-evidentiary status of those videos, simply declaring we do not intend to use them, that in and of itself is not sufficient to negate substantial need. Because that's really the trial court's holding here, is that once you have declared you don't intend to use them, substantial need cannot be. There will never be a substantial need. So I think it needs to be remanded for an in-camera review, but also with some instruction that the evidentiary status or the intended evidentiary status of the video is not part of the analysis, or certainly is not sufficient to negate substantial need.
And is option 4 to affirm the Court of Appeals?
That would be. It's not on my list, but that would also be an option.
Did I miss option 2?
Option 2 would be that in the context of this case, based on
so
this
no bright
record.
line rule, just based on the facts of this case.
Correct.
There is a substantial need here.
Yes, Your Honor.
What about, so if the right way to approach this is through the waiver framework instead of the substantial need framework, and I understand your argument that there may be some overlap between those analyses, or could be some overlap, would remand, if that's the right way to look at this, what would our options be in that case? Would a remand be appropriate, or is that something we could decide as an initial matter?
I think if the court were to take the waiver path, then there would be no need unless there was some sort of
But would
unclear
in-camera
fact.
review be necessary to really decide whether it's appropriate to require disclosure of those materials under the rule of completeness or a subject matter waiver?
I don't believe it would, because I believe what the court would be ruling is that by selectively electing to disclose some of these videos, the defendant has waived the right to assert the privilege over the remaining videos. Therefore, there is no need to have an in-camera review of what the videos
Well, but
show.
doesn't a court still have to decide, what is the scope of the subject matter waiver? What else is sufficiently related to the items that the party does intend to disclose, to constitute a subject matter waiver? I mean, here we don't even have, we know, I know you're telling us that they were, and that's in the record, that we know all of these videos, that the videos that are not on the privilege log were recorded on the same day as the videos. Is that in the record?
I believe it is. I know for sure that it is in the trial court, well, I shouldn't say record. In addition to producing the 6 videos that were contained in the privilege log, the defendants also produced their investigator's report. I know for sure that provides all the surveillance took place on one day. I don't believe that investigator's report is in the appellate court record because it would have been disclosed after we were off on our appellate path. Certainly happy to supplement the record to provide that document.
Is the mere fact, even if that's in the record and we know they're produced on the same day, what if they were different locations? What if it was different, there were some videos in the morning, there were some videos in the evening, and they were entirely different locations? Would an intent to use, one subcategory of those videos necessarily mean that there was a subject matter waiver over all of the videos for the entire day? Or wouldn't the court actually need to take a look at that with a better developed record?
I think in this context, the answer is still no, that the court does not need to do an in-camera review. And I think the cases that we've cited on internal investigations are instructive on that point, where there are cases holding that simply offering part of an internal investigation or placing part of an internal investigation into the record waives the entire investigation. And we don't see the court there parsing out, well, the part that you elected to disclose really only deals with this one concept, and that's the limit of the waiver. The courts are pretty universal in saying, if you want to use part of it, it's all fair game, at least in terms of discovery. And I think the court can also find some comfort in the fact that what we're talking about here is discoverability, not admissibility. And so there's always going to be that fallback of the rules of evidence, a very sort of default Rule 401, 403 analysis as a safeguard to making an argument, well, in this context, we shouldn't allow the plaintiffs to show these videos, even though we allow them to discover them. There is still a safeguard to admissibility and shielding improper information from the jury that I think that should be the appropriate avenue for addressing those issues rather than trying to carve out or narrow the scope of discoverability. There is, and I recognize that I only have about a minute and a half left, so I want to raise one issue that I think is really important, which is in the context of the substantial need analysis, if that's the path that the court elects to go on. The trial court and the Court of Appeals opinion seem to take great concern with the idea of not allowing videos to be produced if this purpose is to corroborate the plaintiff's own testimony. And I want to be very clear that that is not our basis for asserting substantial need. Our position is not that these videos ought to be produced so that the plaintiff can prove her case in chief. And I think when courts talk about corroborating plaintiff's testimony, I read the language of those cases as dealing with plaintiff's burden of proof to check the prima facie elements of her case: duty, breach, causation, injury. The plaintiff has the burden of establishing injury, and so if the argument was, we need these videos in order to prove our own injury, that's what courts have held is not a substantial need, and that is not the argument we are making here. We're not advancing an argument that we need them to prove our own case in chief. We are making the argument that, especially, and I recognize my time is up, but if I finish that thought, especially in the modern era of what is capable with respect to video, I think this court has to recognize that there is a substantial need for probing, at least from a discovery standpoint, whether or not a video that is being shown is misleading, is incomplete, is in some way not providing the full context to the jury. And at least from a discoverability standpoint, I think there is a substantial need in this context, unless the court has any additional questions.
Thank you, counsel.
Thank you.
Good morning, Your Honors. Brigham Dixon on behalf of the Nashville Bar. May it please the court, presenting argument today on behalf of the defendants and appellees. It's also my first time before Your Honors, and of course with the Skills program, so I'm appreciative to be here. There are some foundational issues with the arguments that have been presented by Mr. Zager, and I want to address those, particularly with the record in this case. I think to understand these issues with privilege log, what's been produced, and claims that videos have been withheld that are unsubstantiated, it's necessary to go back to the original motion to compel and the order that was originally entered, and then the subsequent order on the motion to amend or revise that order. We, at all times, have maintained the privilege of the work product doctrine over all surveillance videos. That led to a motion to compel.
When and how did you invoke that privilege?
In discovery responses. They requested all videos, anything we might have of Mrs. Locke. In response to that, we said we object on the basis of trial preparation materials, work product doctrine, impeachment evidence, et cetera.
But would you agree that producing a privilege log is necessary to properly invoke either a privilege or a work product protection?
Yes, and a privilege log was produced. We have a privilege log that was produced, and we've never waived the privilege.
But the privilege log include all of the videotapes, or
Yes,
just the 6 that's being introduced?
And that's why I think there's some confusion here. And what you're referring to is representations by Mr. Zager that is based entirely on what I'm getting at with this, how this order has changed. The order as it was originally written by the trial court, by our interpretation, would have allowed plaintiffs to discover surveillance work product regardless of whether it was intended to be used at trial.
Can we go, sorry, can I step
Yes.
back just a second? Okay, so you've fast forwarded to the order. Let's go
Yes.
back to, you produced a privilege log before the order, the initial order of the trial court requiring disclosure of videos. Is that correct?
We produced a privilege log once I'd have to double check the timeline, and I'm sorry for not having that available offhand, but we produced a privilege log at least when we were required to identify all of the videos under which we would claim work product.
Okay, and are the videos that you do not intend to produce at trial on the privilege log?
And this is a key issue. There are no videos that are not included on that privilege log. The whole basis for this argument is because we sought for the court to revise its order because we felt that it meant any surveillance we obtained at any time, regardless of if we had to use it, had to be disclosed. So we wanted the court to say, can you confirm that's your order, or are you trying to be more consistent and say if we intend to use it at trial, that we must disclose it? The trial court agreed. Now, based on that, plaintiffs and their counsel have surmised that because they have a non-sequential numbering of videos that were provided, that there's some other listing of videos. That's never been represented. That's never been disclosed in the record. And frankly, they've had the opportunity to conduct discovery. They've known who the private investigator was. They didn't depose him. They did nothing to understand what that meant.
I'm not following.
Okay.
So if I understand you correctly, what you're saying now is that the privilege log that you produced actually identifies all videos,
All the videos.
whether you're going to use them or not.
There are no videos from that private investigator listed on that privilege log that we're withholding. The only basis that
Well,
has
right,
been
but
used.
that's sort of,
No,
but
that's not
Yeah,
the
that's
question.
circular.
Yeah.
What Justice Campbell is asking
Okay.
about, what are you asserting work product over?
We've asserted work product over everything in this case that we have, but we've produced it. And we've informed Mr. Zager of
Where
that.
have you identified anything that you are asserting work product over that you are not going to use?
There are no materials over which we've asserted work product in the surveillance realm. Obviously, there's other work product, but as to surveillance, there are no other videos that this firm, my firm, has obtained.
You're saying all this very, very carefully.
Well,
I'm trying to figure out what you are not saying here. I'm
why are we
hearing
even-
holes in what you are describing.
Okay.
And I feel like I'm not getting just a full-on, straight answer. You are asserting, we wouldn't be here today if you weren't asserting work product over video that you think the plaintiffs ought not see. What I'm asking is, where is that identified? In order to assert work product, you have to identify what you're asserting it over. Where is that identified?
So I have to, I don't mean to be cagey, I don't mean to be misdirecting. The issue here is we were ordered to produce what we were intending to use at trial. We did that, and we have no other videos. But the order that was appealed by Mr. Zager because he requested all of the videos, and now there's an order in place that only limits it to the videos that are intended to be used at trial. Now, the reason I think this is an issue, this case is ongoing. There's a future possibility for additional surveillance, and we wanted to know if, under the plaintiff's proposed ruling, that if they have a need for some video, such as what we're going to use at trial, which is not disputed, then they would arguably be able to obtain any future surveillance, anything that is in that category.
Are you saying that this appeal is over as yet non-existent video?
Yes, because the plaintiff has not developed that record whatsoever. If you look in the record, there is nothing there to show that there are videos that have been withheld. It is pure speculation, it's pure conjecture and innuendo.
So
And it's
you're
their
saying
burden.
the trial court first ruled that the videos must be produced, and then you filed a motion to alter or amend to only produce videos that you intended to use, and so you filed that motion for some hypothetical future videos that don't yet exist?
No. The reality here is that we're in Davidson County with an order that can be used with numerous other cases, the largest county in Tennessee. And there's an order in place that said, as we interpreted it before it was revised, that a plaintiff is entitled to surveillance whether we intend to use it or not. We said that's not an appropriate ruling. We want it to be revised. The court agreed based on its own precedent that it relied on and the precedent that Mr. Zager first proffered.
All right, let me ask it this way. Is there surveillance video that you have taken that in existence right now, not hypothetical in the future, in existence right now that you have taken on behalf of your client that you are not, either have not already produced to the plaintiff or are not willing to produce?
No.
Then I'm completely puzzled, Mr. Dixon.
Why are we here?
We're here because he's appealed the ruling in an order that says that you only have to produce videos that you're going to use at trial. That's what the court ordered, and that's what we produced. But he says we should be required to produce any surveillance we ever get, no matter what the category is.
Okay, let me try and ask it a different way.
Okay.
What is the entire length of the videos that you propose to offer at the trial?
At trial, all the videos we have, we intend to offer at trial. That consists of, I would say, no more than 5 minutes, and I've not timed them.
So, okay.
they've been produced.
So you're saying you don't have 30 more minutes of something else over here that you don't intend to use at trial that's not been produced so far?
That's right. And the speculation that's led to this argument has been that there's non-sequential numbering of videos. There's been no discovery into that, and no one knows how that even happens.
Wait a minute, you took video of the plaintiff, and you only took 5 minutes of video? I find that
Frankly,
incredible.
that's part of the record that would have to be asked to the private investigator. We received the videos.
Well,
We didn't
I'm
take them
asking-
ourselves.
I'm
but-
asking you, I'm really trying to figure this out. If this whole appeal is over imaginary, hypothetical surveillance video that might be taken in the future. Yes?
Well, yes, to some degree it is, but it's also a matter of the order that
To some
plaintiff-
degree, what does that mean?
Well, it's not only about that. It's not only about future discovery or future surveillance issue that may be issued in this case. It's also about it is in this case, but it's also about the fact that plaintiff wanted to have an order in place that said defendants always have to turn over their surveillance,
But you
regardless
can't
of the intent
assert,
to
I
use
mean,
it.
we're talking about work product.
Right.
You can't assert work product over imaginary future video. So what are we talking about here?
Could it be about the rest of the investigative file?
I'm sorry? The investigator file?
Yeah.
Yeah, we asserted the privilege over the investigator file as well, and we actually voluntarily turned that over. We've informed Mr. Zaker of all of this. This has been informed to Mr. Zaker. He knows this, that we've produced what we have. So I think
Well,
there's still.
what puzzles me, Mr. Dixon, why did you even file a privilege log? Why did you put items on a privilege log that you produced?
Well, we did that before we actually produced them.
Okay.
And that was helped, frankly, to avoid waiver, and we don't believe there was waiver because we were ordered to produce them from the trial court.
Okay, so what are y'all fighting about in this case?
We're fighting about the scope of an order on how much discovery is entitled to be, or how much surveillance, is entitled to be discovered by a plaintiff. And what the plaintiff has claimed is that anytime they demonstrate a substantial need for some surveillance, that opens the entire category of surveillance to their review.
Well, so is there something in that category of surveillance that you're trying to protect that should have been listed on a privilege log somewhere?
There's nothing that should have been listed on a privilege log that has not been listed on a privilege log. We've listed everything on the privilege log for which we've claimed a privilege, and we're not withholding documents or videos.
Okay.
Now, again, I think this is
Why
important
did
as
I
well.
not get maybe I'm thick here, but I just didn't glean that from the brief.
That's
I just didn't
exactly
glean
what
it
I'm
from
sitting
the
here
brief.
looking back at. I didn't delete it either.
Well, I think that's why I want to try and inform you on the record that they've relied on speculation and conjecture, and it's making you assume that there are some other videos, but they don't cite
But
anything.
you filed a motion to narrow the ruling to require production of only the surveillance videos defendants wish to reserve.
And the-
That would imply to me that there is something you have that you don't want to produce.
The purpose for that was for precedential value, because again, as I mentioned, we're in the largest state, or the largest county, in Tennessee. Other attorneys would use that and say that there's been a precedential value from Davidson County that says you have to produce all surveillance. And we thought that even looking at that order, it was not worded correctly. And the trial court agreed that they didn't mean to word it as broadly as they did. So that was purely to have the court order be consistent with the reasoning that it applied. And the court did that. Now, plaintiff appealed, but when they appealed, they did so without any basis in the record to say there were some other videos out there.
Well,
And
did
we
you
had
make this point to the Court of Appeals?
We made the point to the Court of Appeals that the trial court didn't abuse its discretion and that they made the correct order. And that's all we had to fight about, because the trial court did make its correct order. It just so happens that we've disclosed and provided all of the videos that we're going to be using at trial. So I think this is another key point. We've gotten off on this tangent somewhat of
It
the
would have
applicable.
been It would have been really easy to say in the briefs, we've produced all the surveillance video we have, Your Honors. We've produced all of it that we have, because that, if I understand it correctly, that's what you are telling us here and now. All the surveillance video we've taken, Your Honor, we have produced to the plaintiffs. Why are we here?
Well, I think that also goes to the fact that they've claimed a much broader application of the law, which would lead us to future surveillance, and at that point,
Then you fight over, if there's future surveillance video, then you fight over it when it comes into existence.
but they're fighting over it in a means that would implicate it now.
But
Which is
that's-
why,
I'm sorry, go ahead and
Please.
finish your response.
no,
Well, it seems that the way in which this was argued below at the trial court and the Court of Appeals and now to us, it sort of was all based on this assumption or the premise that we're talking about surveillance videos that were sort of all produced within the same time frame. Right? I mean, I don't understand the plaintiff's argument at any point to have been that we're entitled to surveillance videos that may be taken, in the future. So it just seems like even if the wording of the order may have been, in your view, broader or, subject to misinterpretation or misapplication down the road, I mean, isn't the way in which, hasn't the entire argument about this issue in the proceedings thus far been based on the premise that we're talking about, a category of surveillance videos that is all occurred at about the same time? That seems to be what everyone has been, if any of my colleagues are thick, then I'm thick too, because I don't think any of us really appreciated that there may not actually be a dispute about this particular category of surveillance videos.
the only thing I can say in response is that they've been aware of the facts of this case, but then they've used this to develop this line. There's some additional withheld videos, and there may be later on, there's not currently. And I think that beyond that, we're still talking about work product. And I think that we are at a point where we have to defend the trial court's order because it was correct when they're trying to expand the trial court's order, when this case is still ongoing.
Well,
this
I'm sorry.
No.
Go ahead. As I understood Mr. Zager to say, the investigative report, which has been produced, seemed to indicate there were additional videos. Is that incorrect?
That's incorrect. And also, I note that the videos and the investigative report are not even a part of the record, but that's not correct. They've attempted to build this record on this appeal, again, without any citation to actual documents in the record. It's just speculation and innuendo. And I do want to get back to one point. Mr. Zager never requested an in-camera review. He didn't quite answer your question. They did not request an in-camera review. What they've got,
Well, why would, if they've got everything, there's nothing to review in camera, right?
Right, so leaves us with the question is, they want to get an order that allows plaintiffs to evaluate any discovery anytime some is offered. The practical effect of that on a day-to-day basis in trial work, as you know, is to have a chilling effect to prevent surveillance. And surveillance is the one opportunity that defendants have to assess a plaintiff outside of what I call
We don't usually hear disputes about what might hypothetically happen in the future. I mean, is this appeal moot? Because we don't, we don't know whether any surveillance videos will be taken in the future. I assume that you'll fight with the trial court over that if and when it happens. Is this appeal mooted?
It very well could be, but at this point, the plaintiff has appealed, and we've submitted, and the trial court found that the trial court did not abuse its discretion. We've all agreed that now, at least in the reply brief, that the applicable legal standard was applied correctly, in our view, and that there's no dispute on any purely legal issue here.
We don't need to decide the applicable standard for imaginary surveillance video that may or may not be taken in the future.
And I would frankly submit that there's already a standard for surveillance in the first place, and that is the substantial need test.
I'm sorry.
Please.
Finish your answer.
Well, my answer was that there's already a bright line rule in place, and that is the substantial need test. And what we felt is that the plaintiffs have tried to weaken the substantial need to say, we only have to show substantial need for some, and that is how they get this, they prove that in one way through us saying we intend to use it at trial. But then they say we don't have to show substantial need for everything else. Just by showing substantial need for one subset means that entire category is open. And we've been trying to say that that's not the way the substantial need test works. The substantial need has to apply to everything. And they have to show some substantial need for what they're seeking. In this case, they simply can't show substantial need because they can't even identify what other videos they're trying to seek.
There are no other videos, right?
Precisely. And what they've tried to do is use this speculation, and it's their burden. It's their burden. They have the discovery.
Deciding? You say it's a bright line rule, it's established.
Yes.
Obviously, there is a dispute here about whether it is established or should be changed or modified in some
Right.
way. But we don't decide hypothetical what ifs questions. So why are we deciding this if you've produced everything?
Well, the plaintiff has pursued the appeal to try and overturn the trial court's ruling, and we've just basically defended the trial
But
court's ruling as...
honestly, it's your job to clarify. We've produced everything we've got. That's your job. That's not their job. That's your job.
We've made that clear to them.
But where in their brief is that clear?
The brief is responsive to plaintiff's appeal arguments, and
But why would-
that's why we want to make sure that the state of the law is consistent with the substantial need test and what they've proven. And again, that goes towards
But then
why
would you not say in your brief, there is nothing more to produce? To the extent that there can be argued that this order is too broad for future purposes, or we could argue, here's our argument. Then we would have understood that you didn't have anything else to produce. Then we could decide, okay, are we going to go ahead and hear this or not? But that's not in here.
Well, I think it's clear in the record that he has no basis to claim that there's something out there that has not been produced.
Well, here's what I'm sorry to beat a dead horse here,
Yeah.
but here's what I have a really hard time understanding. So that when the trial court initially ruled on the motion to compel, my understanding is the court's ruling was focused on the materials that the plaintiffs had actually requested. And here's what the court said. It said, defendants have obtained multiple surveillance videos from a precise moment in time. It's impossible for plaintiffs to go back in time and duplicate such a video. So that was the basis for its conclusion, that all of the surveillance videos from that particular point in time had to be produced. I don't read the trial court's ruling to be that, you have to produce any surveillance videos that you come into possession of at any point in the future. I mean, it wasn't that broad. It was really based on what the plaintiffs had requested from that particular point in time. So if you had already produced, or you were happy to produce all of those videos because you were planning to use all of them at trial, why did you file a motion to alter or amend that ruling? That's what I'm really struggling with.
Sure, and I can explain that to you.
Okay.
That original order, and it was, as they've pointed out, there was some discussion of this West case. That was a district court within the Sixth Circuit that kind of provided some reasoning on how a plaintiff demonstrates substantial need. And in that West case, they talked about if what is on the video is going to be different, or is going to show the plaintiff in a different condition than they claim to be, meaning it's impeachment material, then there's a substantial need. And the way you get that impeachment material is it's also been kind of described as you intend to use it at trial. So the way that original order came down was more broad of everything that may be in that day, but we wanted to make sure that it was not misconstrued later for precedential value to say, you get everything. We want only what you're going to be using at trial, and that's consistent with the West case. So we wanted the court to just consider, are you trying to say that we have to produce everything, or just what we intend to use at trial that may be valuable for impeachment? Because that's a big difference in an order, especially in the biggest trial court in Tennessee. And the trial court agreed. The trial court agreed and said, yeah, that's what we meant to do. They changed the order, and that's what's being appealed by the plaintiff. And we say that's an appropriate order.
Did the trial court know that you had produced all the videos?
At that point, we hadn't produced anything. because we had produced our videos after we were ordered to produce it, and that order granting our motion to amend or reconsider is what led us to be required to produce our work product.
But had you made clear that you intended to use all of the videos?
No, at
trial?
that point, I don't
that
believe
point
that
you
we had
had
made
it.
clear at any point, because we maintained at that point that it was work product. And if our position had stood at that point and we weren't required to produce anything, we still would have produced things consistent with the local rules and, rules of civil procedure in terms of being able to use them at trial. But we contended that at that point we weren't required to. And again, at this point, remember, this is a new case that's been filed. This is before the plaintiff was ever deposed in the second case. And it was early in the litigation. They became aware early on that we had taken the surveillance in between the two filings. So little has happened in this new refiled case, despite this having been going on for, at this point, almost 8 years.
Let me go back to something you said a moment ago. You said the plaintiff has no basis to claim in referencing alleged missing videos.
Yes.
There's a difference between that statement and we have affirmatively produced everything. So just want to make sure you are saying you have affirmatively produced everything, not just
Yes.
they can't prove we haven't.
Correct. But I think it's important to consider the fact that they've based this argument, the entire argument, on the speculation. But you're right. And that's why I'm not trying to be difficult. We've produced everything in that privilege log. There's nothing that's being
Not
called privilege.
everything in the privilege log.
Yeah.
You have produced all of the surveillance video that you have taken to date. Yes?
That our firm has taken, and I want to be clear on this. There were
Okay.
prior defendants in
I
this
was
case,
looking
and I don't
for
know.
a yes or a no.
Yes, as to our firm. There's other defendants. I don't know
Okay.
what they've got. They may have. They were not part of the refiled case. Everything that our firm has taken from a surveillance perspective, its PIs that we're aware of, that has been produced.
What
Well,
about
it's-
That
all-
was the subject.
Has your firm represented your client the entire way through?
Yes.
There's been no other firms representing them?
Yes.
Okay.
And I didn't mean to confuse you. There was a prior defendant, another
Okay.
defendant entity that.
Did you represent that other defendant? Okay.
No, and that's why I want to be careful and not misrepresent it, but it's from our perspective, from my firm's perspective, we've produced everything.
do you have possession of videos that were taken by other defendants that your
No,
client has possession
not
of?
that we're aware of Ms. Locke, no, so I want to be clear on that. The videos of
You know,
Ms.
it's a little uncomfortable. We're having to parse the words here.
Well, the videos of Mrs. Locke that we have been produced. And they were produced pursuant to, over our objection and pursuant to the court's order that he had a substantial need for those that we intended to use at trial. It just so happened that what we had, we intended to use at trial.
So are there other videos that you're aware of?
No. No.
Okay, so let me just see if I can put a point on this a bit. This case, we thought was about unproduced surveillance footage. All surveillance footage has been produced?
Yes.
Okay. That's all surveillance footage that you have access to, no matter what the access is.
Yes.
All right. And have you withheld anything on the basis of privilege, which you're certainly entitled to do? But is there anything being withheld on the basis of privilege that has been asked for in discovery by the plaintiffs?
Are you referring just to surveillance? Are you referring
Now, my question was pretty simple, okay?
Yes,
Are
sir.
you withholding anything on the basis of privilege that would be responsive to a discovery request?
Oh, no.
Okay, all right. And as an officer of the court, you've given them everything you got.
Excuse me.
Yes, sir.
No.
Okay. You have not given them everything you've got.
No, we have given them everything.
Okay.
What counsel informed me of, we have videos that are not Miss Locke. That are not Miss Locke. That's the issue with attempts at surveillance. There's things that don't show
Well, who
mislog.
else would it be?
Who y'all
You
out
were just
video?
recording, and you happened to capture a lot of footage that did not have Miss Locke visible. Is that what you're saying? You have videos
Well,
that,
not even from our private investigator. We've received it.
We're not talking about your home videos of your children.
Effectively, yes, attempts to capture Miss Locke that were not successful.
okay. So, sorry, at the risk of continuing to beat a dead horse. So it sounds like there may have been potentially a live dispute on this during the course of the trial court proceedings, because perhaps you did not yet know whether you intended to use certain videos at trial.
Right.
Once it became apparent that you did intend to use all of the surveillance videos of Miss Locke that were in your possession at trial, at that point, would you agree that there was really no longer a dispute, a discovery dispute, a live discovery dispute between the parties concerning these surveillance videos?
Once we produced our videos, yes. But
Okay.
the issue has become that, again, we felt that this would be particularly important to give us the ability to seek future surveillance without the need to, or without the worry that whatever we get would be discoverable.
Because the trial
Under-
court initially said, you've just got to produce all these videos,
Right.
whether or not you intend to use them at trial. And so that's why you sought, you filed the motion to alter or amend to sort of narrow that.
Yes.
And I take it there's still sort of a dispute about the issue of law as to whether, a party's, in the circumstance where a party plans to use the surveillance videos at trial, whether that requires the production of other videos in that possession. So that's an interesting issue of law. I mean, that's sort of why we wanted to take a look at that. But there is no longer, I mean, this particular case at this point in time no longer involves a concrete dispute
If Your Honors,
about the production of any specific materials, right?
if Your Honors were to remand the case and say, which we think would be inappropriate, assuming even if there were videos, but if Your Honors were to remand the case and say, okay, produce all the other videos in camera, there would be nothing to produce.
Okay.
I know I'm
Further-
well over time, but I'm happy to answer any more questions. I know this has been more complicated than anticipated, and I'm sorry for that.
Let me just ask one.
Please.
There's no surveillance videos of Mr. Locke either.
Oh, correct, yeah, then that's never been an issue, yeah.
Okay, that's all.
Thank you, counsel.
Thank
Thank
you very
you.
much.
Mr. Sager, we have questions.
So,
We
so he
beginning
said,
with why are we here?
yeah, so he says you got it all. That's a question. He says you got it all. You got it all?
To be quite honest, Your Honor, I don't know. I think what gives me concern, and I think Your Honor's questions, perhaps most so, tried to get to the point, is if in fact there are no videos in the possession of the investigator but not in possession of the law firm, no videos that are being withheld, it seems odd to me that, one, the investigator's report has missing file numbers. That is a little odd. And two, why on earth then would they file a motion to alter or amend? That would seem to be an entirely unnecessary and inappropriate advisory opinion and a complete waste of this court's time. If there was no actual video being withheld. And I would encourage the court to go back and review not only the trial court's original order on the motion to compel, but also defendant's motion to alter or amend. Because one, the original order does not make any sort of pronouncements or distinctions about videos that one party intends to use versus videos that the party does not intend to use. To your point, Justice Campbell, the order was simple. There's a discovery request that says, please produce your surveillance videos. There's an order granting a motion to compel saying, please produce your discovery videos.
But I take from what defense counsel argued, I mean, I take it to be that was their point, right, is that they didn't know what they wanted to use at trial yet, and they thought that it should be limited to things that were going to be used at trial. So in their view, it was overbroad, the initial order was overbroad, and that it didn't make any distinction between surveillance videos that would eventually be used at trial or not. And if it's true at that point that they didn't know what they planned to use at trial, then that would seem to provide a pretty rational reason for them to file the motion to alter or amend, wouldn't it?
Well, and that's why I say to also go back and read the actual motion to alter or amend, because what the motion to alter or amend presents is not a picture of, just to be clear, in the event there are future videos that we might obtain, we reserve the right to object and claim a privilege over those. Nor does it say, just to be clear, we haven't quite yet made a determination on which of these 6 we'd like to use at trial, and we reserve the right to only have to produce some smaller subset of these. The motion to alter or amend says, just to be clear, you've ordered production of surveillance videos, and we shouldn't have to produce surveillance videos that we don't intend to use at trial. It as I read it, I think as the trial court read it, and it appears as this court read it as well, it seems to be suggesting we shouldn't have to produce other videos that we don't intend to use. We should only
But
have
if
to...
but if the defendant didn't yet know what it was planning to use at trial or not, wouldn't it make sense to ask for that clarification?
It would, but I would have put that in the motion. I would have made that clear to say, just to be clear, we are providing...
Or you guys could talk to each other. It sounds as though the mystery of the non-sequential, the numbering on the privilege logs was there were attempts to video Ms. Locke that, you had the video camera running and she doesn't show up, or, she's just not in that video is probably, but, what I am hearing, and I'll let defense counsel listen to what I'm saying. What I'm hearing is that all of the video that they have of your client has been produced. So if that is the case, is this appeal moot?
I think not necessarily, or yes with a caveat
Then
for this reason.
How is there what's there a live dispute over?
The problem is we have this order from the trial court now amending its original ruling, potentially on the basis of a hypothetical that really shouldn't be ruled on at all. If that's not a live issue before the court, that's really an advisory opinion. But it's there. There it is. And now that trial court has made...
That might be a future problem for you, Mr. Zager, but my question is there anything over which there is currently a live dispute?
To the extent that this appeal is challenging that ruling, I would say yes, because we are challenging that ruling. If we're going to allow that ruling to stay in place, that's a ruling as a matter of law that is now setting forth, I think, a new legal standard under Tennessee law, that as a matter of law, the non-evidentiary status of a surveillance video renders it, you will never have a substantial need. If we're going to allow that order to stay in place despite the sort of hypothetical nature of it.
We don't usually issue opinions on a trial court's order that looks overbroad and might create problems in the future. Just saying.
I think that's the problem.
And that's what you're describing, am I right?
Well, but the order is in place, and I'm not sure what if we can't appeal it in this venue, I don't know the appropriate avenue.
Could we, there's a doctrine in federal, for purposes of federal appellate proceedings that allows, once an issue becomes moot or case becomes moot on appeal, that allows the appellate court to vacate the lower court decision precisely for that reason, so that it doesn't become precedential when the appeal just became moot sort of by happenstance and precluded the losing party below from obtaining appellate review of that. Could we do something similar here?
I think so, and I think that would be appropriate and necessary in this circumstance to say, to the extent the trial court made this extra, apparently unnecessary ruling, that ruling on the motion to alter amend is vacated. We will revert back to the original ruling, granting the motion to compel. There apparently is no additional dispute over surveillance videos that we would have to worry about what happens to those from a discoverability standpoint. So there's no need for that subsequent trial court
And we
order.
would need to vacate the Court of Appeals opinion as well, presumably?
I think unless this court wanted to voluntarily weigh in on the interesting issues that could potentially arise, yes, I think that would have to be the holding, because the Court of Appeals
We
really is
have
just...
no shortage of interesting issues.
I have no doubt. And so the Court of Appeals ruling was really affirming on an abuse of discretion standard the trial court's order on the motion to alter amend. So yes, I think necessarily the Court of Appeals opinion would have to go with it.
Have you tried to get the deposition of the investigator?
We did not, because we felt like under the circumstances of what the trial court ruled, which is essentially that anything other than what's in the privilege log is work product, we felt it would be futile that the same objection, the same privilege would be invoked, and the trial court had already announced its ruling on what it felt about non-evidentiary videos, so there would likely be an instruction not to answer or not respond to a subpoena, and it seemed futile. And I recognize that I'm out of time, but if the court has any other
Any
questions.
other questions? Thank you, counsel, for your illuminating arguments. We appreciate.
All rise. This honorable court is now adjourned. I'll go ahead and have a seat and we'll